Hi, Ricardo Villegas, Practice Director, Visual Legal. I'm here to talk to you about the criminal law, specifically drink driving offenses in South Australia. Now, these offenses come with very heavy penalties. One penalty is you lose your license for a prescribed amount of time. You could also face substantial fines in the thousands of dollars. And who can afford that in today's cost of living crisis? You might even go away to jail for a while, depending on the seriousness of the offense. But worst of all, what I've seen in my practice is what happens to your life. Loss of marriage, loss of custody of the children, loss of employment, loss of income. The effects can be severe. So let's look at how you can avoid these things or what exactly the law is comprised of. So when you're talking about these offenses, you have what's called a PCA, or prescribed concentration of alcohol. That comes from Section 47B of the Road Traffic Act. So what this means is they're analyzing how much alcohol is in your system through a breathalyzer machine or a blood test. The other way to get done in with these offenses is driving under the influence, or a DUI. Now that's what happens with a DUI is when a police officer basically pulls you over and they say, "Whoa, you're a bit drunk, aren't you? You're a bit tipsy, and you're driving a vehicle." So let's look at these offenses in turn. So let's start with a PCA, like 47B. So what happens here is that the amount of alcohol in your system is measured purely by a breath or a blood test. So that's basically it, a PCA, prescribed concentration of alcohol. So you might not even show any impairment. So you might leave the pub or the bar or the club or wherever you were, and you don't feel any effects of alcohol. Yeah, you might have had 1-2 beers and you don't really feel it, because who feels 2 beers, unless you're a complete teetotaler. So, but it's in your system. So you don't have to be impaired. If it's in your system, you have blood alcohol concentration. So that's why they break it down into categories. So now the level of category is the seriousness of the penalty. Well, category 1 is a 0.05 to a 0.079. What that means is anything below a 0.05, you're not guilty. There is no drink driving offense because you're not impaired, even though you do have some blood alcohol concentration, but you're not impaired to a point where you can't operate a vehicle effectively. Most of us end up here after 1 beer. So they do say 1 beer per hour and you'll be okay. Your blood alcohol content will be below the threshold. Now, if you get into a bit higher, you're now in category 2. So that's 0.08 to 0.149 grams per 100 milliliters of blood. We'll examine what that means in a bit. And the most serious category is category 3, 0.150 grams per 100 milliliters of blood. That's basically when that's category 3. So obviously it's a bit more scientific than that, but that's where the DUI part comes in. I'll explain what that means in 2 seconds. So let's look at these categories in turn. So let's look at category 1, the least serious category in terms of the penalties. So there are penalties for these offenses. Let's go through them. Your first offense is a fine and 4 demerit points. Now, because it's your first offense and it's a category 1, it's basically just an expiation notice. You pay it and you move on with your life. It's a lot of money, $771, but you pay it and keep driving, don't do it again. But if you do argue, hey, I wasn't drunk, I was at a 0.049 or something like that, and you want to argue, but you lose, if you lose in court, they're going to give you a 3-month disqualification. So basically you pay it, and you keep driving, go on with your life, you fight it in court, and you lose, 3 months, no license. Well, what if you do it again? So a repeat offense is within 3 years. So anytime in that 3-year window after the first offense, if you do it again, then it's a repeat offense. So the second offense is a fine of $1,100, 4 demerit points, and a minimum of 6 months disqualification. And if you do it again within those 3 years, you get a third offense, $1,100 fine, 4 demerit points, and this time 9 months disqualification. So you see that the penalties keep ramping up, right? So they definitely want to get that ruler and slap you on the hand and say, don't do it again, and the slap gets harder and harder and harder. Let's look at Category 2. So what is a Category 2 offense? The penalties for these are a bit more severe. So the penalties is your first offense, $900 expiation, all right? 5 demerit points, and even if you pay the expiation, you still have 6 months disqualification because the offense is a bit more serious. Now, if you elect to go to court and lose, it's kind of basically the same. 6 months disqualification, 5 demerit points, and your fine can go up to $1,300. Depends how much leeway the magistrate gives you. What about a repeat offense? For here, in this category and Category 3, the repeat offense happens within a 5-year window. Remember, Category 1 was within 3 years. Category 2 and 3 is within 5 years. So they give you a bit more time, yeah? Because if you do it again within a bigger window of time, there's a problem there. So second offense, a fine of $1,100 to $1,600, 5 demerit points, and you can't drive for 1 year. 12 months disqualification minimum. And not only that, there's the potential that they put an alcohol interlock device on your vehicle. It's those, things that you have to breathe into and before your car will start. And if there's any alcohol in your system at all detected by that interlock device, your car doesn't start. Those things aren't cheap. They're expensive to install on the car, and the one who's going to pay is you. You have to pay to install the alcohol interlock device. And the worst part is when somebody gets in your car and they say, what's that? And then you have to go through the whole story and explain that you got done in for a Category 2, the whole thing. What about a third offense? If it happens within those 5 years, $1,500 to $2,200. That's a lot of money. 5 demerit points, 2 years disqualification, and an alcohol interlock device for up to 3 years on your car. So 2 years no driving, and then when you do start driving, you have this thing on your car for 3 years. Ouch. So Category 2 gets pretty serious, but it doesn't even compare to Category 3. Let's look at Category 3 now. What kind of penalties do you have for Category 3? They ramp them up. Like I said, they start getting ramped up. So what happens? $1,100 to $1,600 fine, 6 demerit points, and 1 year minimum of no license. You cannot drive for 1 year. If you go to court and lose, basically the same thing, but you end up with a criminal conviction on your record that you have to disclose in most, applications for employment, applications for Centerlink, anything like that. You have to disclose your criminal convictions. So if you go to court and lose this one, Category 3, first offense, boom. What about a second offense? Remember, these happen within 5 years, so there's a long period of time for that repeat offense. For a second offense in Category 3, $1,600 to $2,400 fine. That's more than I pay for my kids' private school. I mean, not really, but it's getting there, right? 6 demerit points, 3 years disqualification, and a mandatory interlock device. So the magistrate doesn't even have discretion. They can't say, oh, you're a good guy and it happens to all of us. They have to put an interlock device on your car. And when you get to the third offense, 6 demerit points, 3 years disqualification. You cannot drive a vehicle or a motorcycle or a car or a truck for 3 years. And you have an interlock device on your car for up to 3 years. Plus, that fine is not cheap, $1,900 to $2,900. And half of your demerit points allowed are gone, 6 demerit points. So you can see that the offenses ramp up. They get more and more severe. So that's the PCA, prescribed concentration of alcohol, breathalyzer, and blood test. And we'll look at how these operate in a bit. What about a DUI? Well, DUI is a bit different because what a DUI is based on is the perception of the officer who stopped you. And what they're looking at is observation of impairment. The things that they're looking for are, number one, the obvious drinking for a while, probably is a slurred speech. So if you have slurred speech, that's a very telltale sign that you're being impaired by alcohol. The other one is, well, what about if you're like walking like that? You get a bit of a steady, right? If you have an unsteady gait, that's another observation of impairment. And finally, poor coordination. So they might ask you to do something like touch your finger to your nose as you look up and do like lift up one leg. And if you can't do these things, I can barely do them and I'm sober. if I can barely do them now, chances are if you have some alcohol in your system and you can't do them, the cop's going to do you in. Yeah. So now what happens? You might say, well, the breath test said 0.045. Yeah. Or my blood test, the reading was extremely low, but you're still talking like that. And some people have a very high tolerance for alcohol, mainly because they've been drinking for a long time and they built up that tolerance. Good on them, right? Congratulations. But that doesn't mean you don't get done in for DUI, because this is all based on the observations of the officer. And usually they have those body cameras that are recording you as you're doing all these tests. And so if you fight this in court, the officer is going to take the stand. The prosecution is going to run them through questions, and they're going to show the video to the magistrate in the courthouse. And there you are trying to touch your finger, even though your blood alcohol content was very low and not an offense. I mean, all this is a bit dramatic, but I just want you to understand how all this ties in. So obviously what these do is they work together. The police observes that you have impairment, and then they might force you to take a breath analyzer or do a blood test. So that's how that works. Now, the actual law says the following, so that you can kind of see what is going on here. Section 47(2) of the Road Traffic Act: a person is incapable of exercising effective control of a vehicle if, owing to the influence of intoxicating liquor or a drug, the use of any mental or physical faculty of that person is lost or appreciably impaired. Now, those are all fancy words to tell me, as a magistrate, as a lawyer, that this is the discretion of the police officer. Complete their discretion. So they are looking at you and saying, oh, this person is incapable of exercising effective control of a vehicle. It's their observation, not yours. You might say, I'm driving fine. I had 2 beers. I can drive. I've driven after a 6-pack and no problems. But it's not you, it's them. Remember that. So when you come out of the pub and you're like, I'm fine, I can drive, look, do all the tests, yeah, I don't have slurred speech, just be careful, yeah? Because you might get put up for a DUI or a PCA. Okay, so now that all that's clear, what are the offenses? Like, what happens if you have a DUI? You can get an $1,100 to $1,600 fine, 6 demerit points, and up to 3 months of imprisonment. Remember, we're not talking about blood tests where, you might not have too much impairment, you might still be talking normally, but you got a 0.07. What we're talking about here is you're like this, the police sees you and they say, oh man, you are really, really gone, aren't you? You're like toast. You had way too many. You tip back too many at the pub, mate. You shouldn't be behind that vehicle, the wheel of that vehicle. So if you do elect to go to court and, argue that the officer is completely incorrect and fight this thing, you're looking at 12 months disqualification, that's a year, 6 demerit points, and you get a criminal conviction on your record that you have to disclose to future employments, to any applications to the government, Centerlink, Medicaid, that kind of stuff. Repeat offenses within 5 years. It's a long window for this to happen again. And the second offense, minimum 3 years, no license, 6 months imprisonment, going away to the big house for 6 months, 6 demerit points, and a mandatory alcohol interlock device. You can see that these things ramp up really quick and they start to affect your life, which is why I told you, you go away for 6 months, your partner, your spouse, your wife, your husband, they're not going to be happy. What are they going to tell the kids? Yeah. So these things really, really, really can destroy your life. Yeah. So be careful. Don't do it. And if you do it, like, if you're leaving the pub, start chugging water 1 hour, 2 hours before you leave. Just get it out of your system. Go to the toilet a lot. Flush. Put it in the toilet, not in your blood. So before you leave the pub, drink lots of water. Yeah. Now, how do these things work? So let's look at a breathalyzer. So these are police use approved breath analyzing instruments. It comes from Section 47H. And there's a list of all the approved devices. And it's very hard to argue that a police was using a non-approved device because they're issued by the government. So that's almost an impossible ask. It's very, very hard uphill climb. These machines measure alcohol in grams per 200 liters of breath, and they convert that into grams per 100 milliliters of blood. So you might argue, how can you prove that I had this milliliters of blood if you did a breath test? Well, it's all kind of rationed out and calculated. If you have a reading, it's conclusive of blood alcohol content throughout the preceding 3 hours, unless rebutted by blood analysis showing otherwise. Does that all make sense? So you do the breath test, and it says you have alcohol. It says, well, you've had alcohol for the past 3 hours. You have, and then you say, well, that can't be. I have a 0.07. I only had one beer at the pub. I'm not, So you can ask for a blood test just to clear it up. But the blood test has to be done within 3-hour window after the breathalyzer. So it's that like little leeway that you have. So if the blood test shows that your blood alcohol content is 0.04, but the breathalyzer says 0.06, you might have a bit of wiggle room to argue that the breathalyzer machine was broken and we should rely on the blood test. Does that all make sense? It's just a way to give you a defense in case you get caught in one of these, what are they called? The RBTs, random breathalyzer testing on the side of the road. You never know where they're going to be. Cops pull you over. You had a 2 martini lunch. That alcohol is still in your system, but the breathalyzer picks it up because it's a martini, gin, vodka, whatever it was. But you've diluted it. You've processed it through your system. The blood says you're at a 0.04. You go to court. The magistrate's going to say you weren't. So there you go. That's how it all works. Now, if you refuse or fail to provide a sample, it's a minimum of 12 months disqualification. It's almost like an assumption. You're not doing the test because you know that there's alcohol in your system. So we're going to mandatory minimum 12 months disqualification. Or if you do it again and again and again, 3 years minimum for subsequent offenses. So that's how that law works. And those are the sections, 47K, 47E, it's all there. Now, what about the blood test aspect of all this? So let's look at that. So what the blood test does is, if you don't do a breathalyzer because you're medically impaired, you have asthma or something like that, and a lot of clients come in and they say, oh, well, they stopped me at an RBT and I refused to give them the breathalyzer and I said I had asthma, so they made me do a blood test. So there's not a lot of way out of this. So they can require you to do a blood test, and what they'll do is they'll either take you to the station and have a nurse come over and do it for you, or they'll take you to the hospital and they'll do it there. Medical practitioner, nurse, somebody who can take blood. They'll send that blood off to an analyst, an approved analyst, approved by the government. That analyst will then prepare a certificate, a Section 47K subsection 4 certificate that says that you have blood alcohol content at this amount, category 1, 2, or 3. Remember those? So you cannot argue against this certificate. It's the presence of a drug or a drink or alcohol is presumed accurate. So whatever that piece of paper from the analyst says, that's the truth. Yeah. And how do you rebut it? You have to prove that the machines were faulty, that the analyst was negligent, or something like that. And how do you prove that? I don't know. I haven't been able to do it. Well, what do you get? Like tests from the machines? It's really hard. It's a long uphill climb. So yeah. So there you go. So refusal without lawful excuse triggers the same automatic disqualification as a breath refusal. So if you refuse the breathalyzer because you have medical issues, and they say, okay, we'll take the blood test. No, I'm afraid of needles. I refuse to have needles enter my body. That's automatic disqualification of your license for the 12 months because you refuse to do the blood test. So I hope all that made sense. It's a very confusing area of law, and what I went through was just a summary of the many, many sections of the Road Traffic Act that deal with drink driving and drug driving. So if you have these issues, if you have problems, contact us here at Visual Legal. We can help you out. visual-legal.com.au. That's visual-legal.com.au. Give us a ring, book a free initial consultation. I won't charge you an arm and a leg to look at PCI, PCA, DUI, or a refusal to take the breathalyzer or the blood test. I'll help you out. We'll work on this problem and we'll figure it out together. So remember, at Visual Legal, we defend these charges. We assess defenses, either medical defenses, procedural defenses, evidentiary defenses, and we'll come up with a plan to help you out of the situation as best we can, because the last thing you want is for your life to go completely wonky because of one of these offenses. So give us a ring, visuallegal.com.au. That's visual-legal.com.au, 0404-980-963. My name is Ricardo Villegas, Practice Director of Visual Legal, and I'm here to help you out of this jam. Visual Legal.